Welcome, I'm Sharon Kreider. I'm a CPA and an enrolled agent in Sunnyvale, California. I teach tax update classes for tax professionals. This is an update on the Supreme Court decision on the Affordable Care Act, healthcare reform, Obamacare. In a 5-4 decision, the Supreme Court determined that the individual mandate and thus the Affordable Care Act was constitutional. A 5-4 decision isn't unusual out of our court. We have in the past few years had many 5-4 decisions, but normally our court is divided between the conservatives and the liberals. In this particular decision, Chief Justice Roberts moved to the other side to determine that the individual mandate that assesses a penalty for not having insurance for individuals in 2014, that penalty was a tax and within the power of the government to determine and assess taxes. So let me summarize what the bill does. First of all, the Affordable Care Act requires all Americans to have insurance beginning in 2014. So that's the insurance mandate. If you have insurance now, it's grandfathered in. If you have Medicare or Medicaid or other kinds of insurance provided by your employer, that's grandfathered in. This is a mandate for those people who do not have insurance to have insurance in 2014 or pay a penalty. Penalty is small at the beginning, $95 a year, not a month, for failure to have health insurance. Now, in addition to the insurance mandate, there is also a requirement in the Affordable Care Act that each state establish an exchange. You know from reading and listening to the media that the exchanges are very hotly contested by some of the states, and some governors have refused to form exchanges. But the exchange is nothing more than a marketplace for you and I to go buy health insurance, or for our client to buy, or the business to buy health insurance to meet the insurance mandate. It'll be like a marketplace with a big pool of applicants. If a state chooses not to form an exchange, the federal government will come in and form it for them. So in 2014, exchanges will be available to find the insurance to comply with the mandate. Part of the Affordable Care Act, and a very popular part, which took effect in 2010, allowed adult children, those children between 19 and 26, to go back on their parents' health insurance. Whether they're in college, doesn't matter. Whether they live with the parent, doesn't matter. Whether they're a dependent, doesn't matter. It is just allowing that pretty healthy group to come back on the parent's health insurance plan. 2.5 million young adults between 19 and 26 went back onto health insurance and now have health insurance. Medicare tax, very expensive beginning in 2013, will be a very unpopular provision to generate a lot of money, $210 billion, to help pay for the Affordable Care Act and the insurance provided for the subsidies for those people who can't afford insurance. The 3.8% Medicare tax will be on net investment income, interest, dividends, annuities, passive income, rental income, capital gains, all what we know as unearned income, will be subject to 3.8% Medicare if adjusted gross income of the single person exceeds $200,000, married filing joint $250,000, starting in 2013. Flexible spending accounts also in 2013, the amount that you can contribute to a flexible spending account, for we tax people a Section 125 cafeteria plan, the amount that you can put into the medical portion of a flexible spending account will be limited to $2,500. The national average for the contribution is about $1,400, but our clients have been putting in a lot more for dental and optical and expensive co-pays, all of that added together, now reduced for pre-tax dollars in your flexible spending account to $2,500. And finally, a change for 2014, employers, defined as large employers, must provide affordable insurance to their employees. So first of all, large employer is defined as one having more than 50 full-time equivalent employees. That's going to be a technical definition that combines the work of all of my employees to determine how many full-time equivalents I have. Those people who work more than 30 hours a week, 120 hours a month, will be determined to be full-time equivalents. This definition is to stop me from taking my 60 full-time people, cutting them all to half-time, having 120 half-time people and saying, aha, now I'm not required to provide full-time insurance. Lots more detail on this coming up in the next several months as the IRS gears up for what employers will need. So that's our quick e-video alert on the Affordable Care Act. I'm Sharon Kreider.